Your lunch hour with us, super excited about today's presentation. Looks like there's a lot of interest, and we're excited. As you know, the Federalist Society is formed on three basic principles. The first one is the state exists to preserve individual freedom. The second is the separation of powers is inherent in the Constitution and structured in order to preserve that individual liberty. And third, it is emphatically the province of the judiciary to say what the law is and not what the law should be. So, with that, the Federalist Society proudly welcomes Mr. Matt Bowman from Alliance Defense Fund in a debate today with Professor Tucker Culbertson, who will be joining us again in a couple of minutes. I will introduce first, biographically, Professor Culbertson. He's an assistant professor of law here, and prior to joining the faculty, he was a fellow at the Center of the Study of Law and Culture at Columbia. And he's a lecturer in political science at San Francisco State University and UC Berkeley. His research and writing presently focus on, among other things, colorblindness, marriage, and extraterritorial application of the Constitution.
I apologize for walking in the midst of my introduction. I can't imagine something more rude to our guests or to you.
Can I restart? And
No.
His recent forthcoming works appear, among other places, in Washington University Law Review, University of Miami Law Review, Stanford Law Journal of Civil Rights and Civil Liberties, Women's Studies Quarterly, and 2 anthologies of critical legal theory. He earned his JD from UC Berkeley and is currently pursuing his PhD at UC Berkeley in Jurisprudence and Social Policy Program. Mr. Matt Bowman serves as legal counsel with Alliance Defense Fund at its Washington, D.C. Regional Service Center, where he is a key member of the Life Litigation Project to protect the sanctity of human life. Before joining ADF in 2006, he clerked for several federal judges, including the Honorable, now Justice Samuel Alito. He is admitted to the Bar of Michigan, U.S. Supreme Court, District of Columbia, and the Courts of Appeals for the 2nd, 3rd, 4th, and 9th Circuits, and several federal district courts. Practiced law since 2003. He earned his JD from Ave Maria School of Law. He represents 2 Christian colleges currently in lawsuits against the recent mandate from the HHS that the debate is focused on today. So without further ado, please help me, join me in welcoming Mr. Bowman.
Hello, please continue to get food, eat your food. I'll try not to upset your appetite too badly. I was in the hall before this talk and someone said, "Oh, is this going to be the talk about the birth control thing?" And so my message is here is, no, this is not about the birth control thing. This is about the religious freedom thing, okay? So that's going to be the theme of my presentation. If you take nothing else away, this is the religious freedom thing. I represent 2 colleges that are Christian. They're actually not Catholic. Most people think this issue is a Catholic issue. They're Christian colleges in lawsuits that we filed against the Department of Health and Human Services and other departments against the mandate that they cover, without any cost sharing, certain items, namely contraception, sterilization, and other items that they object to. Now, these colleges object to certain items. Here, this is the reason that they give. They believe that human life begins at fertilization, when the sperm and the egg combine, and that some items, which are labeled by the FDA as contraceptive, cannot actually act to, after that sperm and egg have combined, but before it has traveled down the fallopian tube and implanted into the uterus, to prevent the implantation. So they actually do cover contraceptives for their employees, but they object to covering the items that they deem are abortion-inducing at that very early stage. But there are other entities, mainly Catholic entities, that object to including contraception or sterilization proper in their health insurance coverage because of a view of, their view is that sexuality, as deemed by God, excludes these items and their participation in them. But the question here that I want to raise today is not what you think about birth control. It's important to distinguish your views on birth control, for or against, with the issue of whether you want to live in a society that makes room for conscientious objection. regardless of your view on the substantive issue. Do you want to live in a society that makes room for freedom of conscience. And so I think it's helpful to think through this distinct from the birth control issue. Obviously, some of the main conscience conflicts we've had in the law in our history have been about war and draft during the war. And would we want to live in a society where someone who objected to the draft was forced to work in a tank factory or a missile factory? It could also be helpful to think about this. We know that courts often assign lawyers pro bono work after they become practitioners. If you were, let's say you were a doctor in a state that had capital punishment, would you find it tolerable for the estate to assign you pro bono work to assist in executions against your beliefs? Suppose you ran a manufacturing plant in somewhere in the United States. Would it be acceptable for the government to force you against your beliefs to enter contracts with the Department of Defense, perhaps to build implements of assassination or other activities in the war on terror to which you might disagree? If you were a psychologist or a counselor, would you want a state to determine in its licensing or in its awarding of degrees at state schools that unless you were willing to engage in therapy that converted people who have same-sex attractions into people who have heterosexual attractions? There is this therapy. Suppose a state decided that this therapy is something that you have to agree with and help with, or else you can't get your degree. Would that failure to accommodate conscience be something that you would find tolerable? What if you sold food or cosmetics, and you had a company selling this? Would it be okay for the government to force you to test the products in a way that would apply extensive and excruciating torture on chimpanzees or kittens with the food or the products that you're using? Especially if there was an alternate way to test them. Perhaps, what if you were an environmentally responsible automobile manufacturer? Would it be acceptable for a government to force you to sell only gas-guzzling cars, imposing a 12-mile per gallon maximum and prohibiting you from selling alternative fuel vehicles? The point is that you don't have to agree with the ethical views for or against these practices, or against birth control items or abortion-inducing drugs, or for or against the position of my clients that are Christian groups against this mandate. The question is, should our society freely accommodate conscience in areas like this? Now, in fact, in our history, our society has generously accommodated liberty of conscience and has embodied these accommodations in many specific protections in federal law. Now, the most obvious of these is the protection for free exercise of religion in the First Amendment. Now, many people cite the 1990 Supreme Court case Employment Division versus Smith as restricting the protection that the free exercise clause provides. And to a degree that's true, but I want to let you know that the news of the death of the free exercise clause has been greatly exaggerated. Although the court declared the clause to not require a high level of scrutiny to laws that are neutral and generally applicable throughout society, the Supreme Court later, and many courts of appeals following, have gone on to extensively broaden the category of laws that are not generally applicable, and has said that those laws do receive the highest level of scrutiny, the strict scrutiny, when they burden religious beliefs. In particular, in the Supreme Court case, the Church of Lukumi Babaluai versus the City of Hialeah, Florida, and many cases follow it, the court has essentially said, and I'm paraphrasing, that where a law allows a variety of secular exemptions, it cannot refuse to offer a religious exemption. It faces strict scrutiny if it does so. Now that's the First Amendment, but that's not where we stop. That's just where we start. After the Employment Division versus Smith case in 1990, a broad bipartisan majority passed a law that President Clinton signed in 1993 called the Religious Freedom Restoration Act. Now, this is a statute that says, when the effect of it today is that when the federal government does something that burdens free exercise of religion, that substantially burdens religious beliefs, then the federal government faces strict scrutiny regardless of whether the law is generally applicable. So even if it's generally applicable, even if you lose under Smith, you get strict scrutiny under RFRA. Strict scrutiny is the most rigorous scrutiny known to constitutional law. It's not quite fatal, in fact, but it's pretty close to it. The Supreme Court, in fact, applied RFRA, the Religious Freedom Restoration Act that President Clinton signed in 1993, in favor of religious beliefs in the 2006 case, Gonzalez versus Ocentro Espirita. This was a case where a religion proposed that they had a ceremony in which they would imbibe a tea that had a hallucinogen. It was a controlled substance. Now, there was no other exemption in the federal law allowing other people to imbibe this hallucinogen. And yet the Supreme Court said this fails strict scrutiny. And they had reasons for doing that, but it wasn't really a tough call. But we don't even stop at RFRA. The protection for religious conscience in our legal history in the United States is even broader than that. Federal health policy specifically has nearly universally included statutory exemptions for both religious conscience and for moral convictions. And these exemptions were championed and codified, notably, starting in the very early 1970s. In 1973, Senator Ted Kennedy spoke in strong support on the floor of the Senate and voted in what was a nearly unanimous vote in favor of a law that's referred to its author, Senator Frank Church, called the Church Amendment, which imposes a very broad exemption based on religious or moral conscience, not only to abortion, participation in abortion and health, but also to sterilization, and part of that law applies to any lawful health service. So these are, this is a federal law. It's on the books today, and putting aside that the current administration had some quibbles about implementing regulations on that law, they say that this law is enforceable and it's binding, and that they intend to enforce it. And this is on the books today. It's been on the books for nearly 40 years. Then Senator Daniel Patrick Moynihan, in the early 1990s, sponsored a bill that would have applied to First Lady Hillary Clinton's health insurance reform law if it had passed. And that law offered an exemption again for religious beliefs and moral convictions to mandates that would have happened under, what is arguably pejorative term, Hillary care. But that version of that law would have had a religious and moral exemption sponsored by Democratic Senator Daniel Patrick Moynihan. Now, President Clinton himself, after signing RFRA, signed multiple federal laws that still exist today that include religious and moral belief exemptions in health policy. For example, a 1997 statute exempts, quote, Medicaid managed care organization, so these organizations managing care under Medicaid, from having to provide, reimburse for, or provide coverage of a counseling or referral service if the organization objects to the provision of such service on moral or religious grounds. Now, he signed a similar law applied to Medicare Choice. He passed a regulation that came from his own administration applying to the Federal Employees Health Benefits Program. He passed a law governing the District of Columbia and a health mandate there. All these were signed by President Clinton, providing religious and moral conscientious objections. So it's somewhat troubling to me in the tenor of the debate on this issue that when a bill was offered in the U.S. Senate last month that would have simply placed this same religious or moral exemption applicable to the Affordable Care Act, the Patient Protection Affordable Care Act is what we're talking about here, this passed 2 years ago, that this bill would have attached a religious or moral exemption to the mandate that we're discussing today, consistent with all these existing statutes and laws. Opponents of this bill claim that it would have essentially made women into property and sent us back into the Dark Ages. I think that that's overblown. The question before us is whether the request for freedom of conscience from the existing mandate is totalitarian. Is it oppressive? Is it intolerable to suggest that the federal government, while it mandates birth control coverage by 90% or more of the country who don't have objections to it, religious or moral, is it oppressive to say, well, but it should exempt religious and moral objectors in the light of almost universal bipartisan history of not only religious freedom, but health law protection saying the same thing. Would living in a country like that had that exemption, be the equivalent of living in totalitarianism? What seems to me the fact is that all of us in this room, in this nation, have lived in that very country every day of our lives, including today. The mandate we're debating today doesn't go into it's in effect, but it doesn't apply until to plans until the plans start after August 1st. So as of today, March 28th, 2012, health insurance providers are free and have been free for the last 220 years to not be subject to a federal mandate that they cover birth control if they have a religious or moral objection. We've been living in this state, in this status, for our entire known lives. And we've always and everywhere been under this regime. So the dark ages that a conscience bill would have sent us back to are nothing more than the legal regime existing a month ago. And that hasn't even been put into effect. In addition, I think something else needs to be made clear about the underlying facts of a conscience exemption. We're not talking about the question of whether, in this debate, we're not talking about the question of whether to take away the mandate altogether. Before this mandate, studies show that over 80% of employer plans already covered contraception. Before this mandate, contraception for lower income women was and still is not only covered by, but heavily subsidized by federal and state dollars through the federal Title X and Medicaid programs. The HHS mandate makes birth control coverage universal on plans, and we don't have any numbers to show how many people would actually have religious and moral objections. I think it's reasonable to suggest that certainly less than 10%, maybe less than 5%, what people would even have, entities would even have objections to this. Because a lot of those entities, the people who work there, would not agree with the beliefs of the entity. Maybe not all of them, but a lot of them do. And the fact is that a conscious objection here would not stop the federal government from providing this stuff itself without mandating that any employer provide it against their beliefs. In other words, even with a conscious accommodation to this mandate consistent with all the laws I've discussed, this mandate would bring contraception access from what was already nearly universal to being just about statistically universal, even with this exemption. For this reason, the failure of the mandate to accommodate religious objections really makes it illegal under RFRA and the First Amendment for several reasons. I'm just going to cite two that are fatal to the government's case. The first one is, as you know, strict scrutiny requires that the government has the burden to show a compelling interest for what it's doing, attacking the religious believer, and that it is narrowly tailored to achieve that goal, and there's no lesser restrictive way to achieve the same goal. Now, as I mentioned, the government could open up a shop that says anybody who comes here can get a free policy to cover contraception for free. They could do that. The fact that that is a possible option means that it's not the least restrictive means for the government to force an objecting employer to do it. In addition, the Affordable Care Act is not generally applicable. In other words, it gets strict scrutiny even under the First Amendment. Why? Because it has a bunch of secular or religious exemptions. It exempts the Amish entirely. It exempts plans that are grandfathered. The president said you can keep your health plan. That means if your plan hasn't really changed since 2 years ago, those plans are exempt from this mandate. They don't have to cover this stuff. It exempts several discretionary exemptions have been offered by the department. They're temporary, but they can be renewed to businesses. And the president's proposal exempts churches that only serve themselves, which doesn't cover my clients, it doesn't cover most religious groups, but it does cover some churches. So there are a variety of exemptions. When you have a law that says, we're going to impose the mandate, but you don't have to comply, and 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 then my clients come along and say, why should we have to comply? It violates our beliefs. That shows that not only is there no compelling interest to the law, but it's not generally applicable. If there was a compelling interest to force my clients to provide this stuff, when the government could do it itself for free, then they wouldn't have all these other exemptions. So in closing, I would just emphasize that don't let your substantive view on the question of birth control access cloud your judgment about whether you want to live in a society that makes no allowance for the liberty of conscience. Because people controlling the highest levels of power are not always going to agree with you. The party you agree with might not be in office always, as we've got two very different administrations in the last two that we've been seeing. And when people who disagree with you take control, they might remember whether your party was willing to follow our tradition of accommodating conscience. It seems to me that our society has never been more diverse. Its strength is in its diversity and pluralism, and the reason we've been able to be strong because of that is because our historic, generous provision of freedom of conscience, and that's what I think should be the answer to this debate. Thank you.
And now, Professor Culbertson will respond.
I'd like to take a moment to thank John, to thank the Federalist Society here at the College of Law, and to thank the Federalist Society nationally for regularly showing deep commitment to serious and not polar debate, and certainly on this campus of this school, the work that John Marshall has done to allow events like this to occur is inimitable. I'm not sure how closely you all have followed these issues. I'm not sure how many of you have heard or read our guest already, but his presence is very much appreciated, genuinely, in that his role not only as an advocate for clients, but as a public intellectual representing and trying to frame a productive way to approach this argument, this issue, is nonstop. And most of the radio programs I've heard, I mean, you're frequently subjected to ridicule and abuse, and I mean that literally, and I'm grateful that you do what you do. How long do I have? 16. Okay. Well, I'll talk about you for a little while. Any handsome? I mean, that is true, but I certainly don't think that's not a good way to be. You know, it's interesting. The argument made at the outset, and the argument that's certainly made by many advocates as well as religious organizations, is that this is not about birth control. It's not about birth control. It's an argument about religious freedom. The way the argument is represented today is even broader, that it's not about religious freedom, it's about freedom of conscience. And I can't accept it. I can't accept that. I think it is about both. I think it's very much about both, at least for certain individuals that I want to invoke, and about whom I have concerns. And after I discuss these individuals that I will take as archetypal for the kind of question we have to deal with, then what I'll do is give you again, for those of you who don't have it already, just a crude and insufficient history of the provisions in the Act, the rules and regulations issued by Health and Human Services, and the recent final rule and attempt to offer what the administration alleged was a concession and compromise in the sense of this year-long waiting period before imposing sanctions. And I'll do all that in order to finally land where I land, which is to say, on the basis of the Free Exercise Clause, I want to challenge the constitutionality not only of, well, I do want to challenge the constitutionality of the present state of religious exemptions, because I think that those exemptions violate the free exercise of believers, employees, whose free exercise includes the right to sin against their own God, against their own beliefs. And that the exemptions, even if they were crafted in a broader way to allow for freedom of conscience, as was described earlier, would still impose violations on the free exercise of women who believe that contraception is against the law of their God, and who nonetheless, in their lives, decide to use it. And so it's in the interest of their free exercise in the form of sin, that I want to make an argument not to defend the Obama administration's present position at all, but to suggest that the Free Exercise Clause demands something much further. It demands that the exemptions granted for any religious institution may not be maintained. And I make that argument based on the fact that I take the Free Exercise Clause to refer to, not conscience broadly, but rather to the specific practice of religion. And who engages in religion? So far as I feel comfortable saying that natural persons, meaning human beings, engage in religious practice, and that institutions, like universities, like churches, like nonprofits, do not. These institutions are incorporated, right? Even if they are not for-profit corporations. I don't mean to suggest they are. But they are incorporated persons. They are legal persons. But, and this will be my final argument, we have always, under the U.S. Constitution, and like it or not, we have always made distinctions among different types of persons as to what rights properly apply to them. So corporations certainly have rights to speech. They don't have a right to vote. Right? Alien residents certainly have rights to some forms of due process and equal protection. They do not have the same right when it comes to search and seizure or other rights that are tied to not persons but the people. And they certainly do not enjoy the privileges and immunities of citizenship. Right? So there are many types of persons in our constitutional order, and they certainly include folks like my colleagues Klein. But I don't think such persons as those can exercise or claim the right of free exercise of religion. It's funny at these lunchtime events, whether it's for FedSoc or for ACS or for NLG, I always end up coming out as something. Sometimes I came out as queer, sometimes I came out as celibate, sometimes I came out mentally ill. No, that's true. That's true. It is. It's important. And today I'll come out as a Christian. Right? A student of Christ and a believer. And so for me, I say that not simply because, although I do say it for this reason, it sort of defends me against my arguments. But it also is the basis for my deep concern about the free exercise rights of employees who work at religiously affiliated institutions. And my concern is their free exercise. So, let me just say first, and I've already sprung it, I want to suggest that when faced with a genuine belief, a religious belief, at least this is my experience, so this is partly a legal argument, it's partly just a personal reflection, but based on my own experience, to walk around the world believing that there actually is religious law under which I have obligations, right? That's a real thing. And making the choice not to follow the laws of one's God, either because they're inconvenient, or because you're just not sure about them, or because exigent circumstances have you in a situation where you're just not sure what you ought to do, and so you attend to your physical life and not your spiritual life. To me, that's the very core of free exercise. my free will to either abide by religious principles or to violate them, and if I violate them, perhaps repent, whether I repent or no, to suffer the judgment of a God. That's my business. That is deeply and profoundly my business, and I promise you that if it's wrong, what I'm doing, in my sin, I don't need the clergy or a university or anyone else to try to keep me from my sin. The Lord will handle my shortcomings. Right? And so my concern is how it is that the Obama administration has proceeded to single out certain religious groups for total exemption. To single out certain, not even religious groups, but policies to grandfather in. Policies which are grandfathered in, which have been held with either an insuring entity that simply doesn't cover contraceptions or other medications which can be used to cause early term abortions. It's not only contraception that can be used in this fashion, of course. Those insurers or particular plans that don't provide any subsidy for contraception, if that plan is grandfathered in, right, you're still shit out of luck as far as getting your contraception covered. And the Obama administration has chosen, for strategic purposes it seems to me, to focus on what was an inevitable conflict with certain, I think its attempt was to focus the conversation on a conflict with large-scale, organized religious institutions, right? Primarily the Bishops of the Catholic Church, right? In an election year, to suggest that these institutions are anti-woman. That's a conversation for another day. I'm suggesting that if this is a generally neutral law of general applicability, how you can grandfather in policies and exempt whole communities from what I take to be the deeply compelling interest in allowing women to prevent themselves from becoming pregnant, given the physical, legal, moral, social consequences, given what it is to have your body truly kidnapped, right? Even if you love it, right? That compelling interest to allow for not only women's autonomous choice, but also to allow women, if they so choose, to safeguard themselves from sexual violence and consequent pregnancies, to safeguard themselves from having to make the greater evil of a choice in the context of abortion if their spouse is dangerous and would be dangerous to a child. Right? All of those decisions seem to me to be deeply compelling interests. I do disagree on the factual account that many are putting forward that contraception is simply readily available to all in an inexpensive fashion. I think that is true for a large portion of the society. And it happens to be the case that I tend to be most concerned about the other portion, that small percentage for whom the cost of unsubsidized contraception and freedom from a pregnancy is in fact a terribly expensive and terribly serious undertaking. Okay. So we have an Affordable Care Act, and we can talk about that in all kinds of terms. Within this act, preventative care is defined to include access to contraception, right, among other things. And specific institutions, not specific persons of faith, but specific institutions as well as some communities, are fully exempted from the obligation to choose an insurer who will make contraception, among other products, free of charge. Right? I find that upsetting. again, because I am deeply invested in the free exercise of a believer who chooses nonetheless to take contraception. After the initial promulgation of the rules, and after much discussion and protest, the Obama administration attempted through the HHS to advance new regulations, the most recent of which came out in February, suggesting that religiously affiliated institutions, such as universities and other institutions, would not themselves have to pay for an insurance policy which facilitates an immoral act, namely contraception and other abortifacients, etc. In doing so, they have claimed this to be a sufficient compromise. Right? The bishops, as well as many others, don't see it that way at all. But I want to suggest that it's something far worse than an adequate compromise. It's a perpetuation of the wrong at the heart of the religious exemption in the first instance. Because again, and I'll stop with this, but I want to argue to you today that, and we can see it in many of, I won't worry with it now, I'll pull it up for a rebuttal, but in many of the discussion, we're talking about the free exercise of a church, the free exercise of a college, the free exercise of a nonprofit corporation. And I want to stress that in my understanding, those institutions, while they facilitate the free exercise of religion, corporate persons cannot enjoy the protections of the free exercise clause because they do not themselves as institutions pray or face damnation. Instead, they are incorporated legal persons in which individuals pray and face damnation. And at that level, it seems to me that the free exercise of individual CEOs or executive directors or university presidents or bishops is sufficiently protected insofar as they are not obliged themselves to engage in this immoral practice. Now, the chink in this argument is that the very earliest, and then for a while the only surviving, free exercise claims involved situations where a person was forced to choose between observing their faith and quitting their job, working on the Sabbath. Right? That's the major chink in the compelling argument I just gave you, which is to say that if a person felt obliged to choose between serving one of these corporate persons that I say has no free exercise rights, or violating their religious beliefs, then we might well have a problem. But the question I'd like to pose, and I'd love to hear more about, is if we understand this to be freedom of not only religion but conscience broadly, and if we take it as seriously as you suggest we should, wouldn't that then apply to every employer? If an individual of conscience working for the government, who you suggested could be providing these medications and prescriptions free of charge, couldn't any government worker then say, I'm forced to choose between my faith and my job? And aren't we then back to square one? And so if we take it to the level of conscience, I wonder whether and how we can ever limit the categories of those who receive exemptions, just as I find the entire exemption for the Amish and the original exemptions for churches and similar institutions troubling. I also feel that if we were to allow the government or insurance companies or anyone else to step in so that the religious institution didn't have to actually pay for the pills, right? Couldn't we run into the very same problem with any employee of those companies forced to choose between their conscience and their job? And so for me, it seems that we're faced with a balance between deep disdain for a practice, which is nonetheless, I think, attenuated in its directness. I think that paying a premium to an insurance company, which also pays subsidies for people to access contraception, is many steps removed from working in a tank factory or testing cosmetics on animals. insofar as there is a chain of multiple actors between the payer of the premium and the producer, let alone the user of the contraception. So that's what I'll offer for now. Again, I want to stress that I think we need to take the free exercise clause very seriously, and that if we do so, the Obama administration's present plans and policies are in very deep trouble. But I think the trouble I want to bring to the table moves in the opposite direction of my colleague. Thanks.
Thank you, Professor Culbertson, and we'll invite Mr. Bowman back up to respond.
Thank you. And thank you, Professor Culbertson, for your comments and for the, I think, the cordial and civil character of this debate. I think that's refreshing and essential to all of us as lawyers and as members of the profession. I have three things I want to respond to, but they all, I think, are united by a theme, which I think it's not unfair, although I'm open to characterizing it a different way, to identify as a theme of individualism, for lack of a better term. Professor Culbertson proposes that the employees of an entity that objects to providing contraceptive coverage are having their free exercise violated by the company. It seems to me that the first problem with that idea is that the issue isn't allowing women to prevent themselves from becoming pregnant, because we're not talking about a law that outlaws the woman from using contraception, or even from buying it, or even from getting it covered by government subsidies. We're talking about whether the government can force her employer to help her do it. So if the idea is, well, I'm an individual and I have free exercise rights, and that means the government can't stop me from doing what I want to do, I get that. If the idea is, I'm an individual and I have a free exercise rights, and that means you have to help me do what I want to do. You have to help me choose to sin. I can make you a private person who also has rights, which I'll talk about in a minute, force me, or help me. I can make you help me. It seems to me legally that doesn't apply at all, because the free exercise clause only tells the government that it can't restrict what I'm doing. The free exercise, a private corporation can't possibly violate the free exercise clause of the First Amendment just as a legal matter. But I think it misses a bigger point, which is this. Even supposing employees have the free exercise right to choose to sin, you've got other employees who have a free exercise right to associate with people who oppose contraception, for example. So maybe there are people who, and there are, people who associate around a set of beliefs, and we like to get together and do something in society. We like to have a school, we like to have a business. And we want to operate around this common set of beliefs. This is our core, this is who we are, we're a group, and one of those is opposing contraception, and the government is violating our free exercise to associate with each other around this set of beliefs, because we all have to violate those beliefs. And I think that, so I think that's the problem with taking this individualistic approach, and I think it leads to the point that Professor Culbertson made, that, well, these are natural persons, not only natural persons have free exercise rights, not corporations. I think that this misses the fact that constitutional rights have always been interpreted and viewed as not only being possessed by individuals, but being possessed by individuals so that they can gather in groups formed around a belief, and that they can operate as an association. We are not a country that only deals with the government and little atoms of people. Those atoms of people can form associations, and those are real groups. Like, the whole is greater than the sum of its parts in those instances. So there are things between, if we propose a model of society where you've only got the government and atomized individuals who can't form groups like associations, churches, whatever it would be, there's nothing in between the individuals and the state. If the state ever wants to, this seems to me there's a power play by the state to sweep away associations, unions, people forming groups so that they can be stronger as they're united. Those groups have rights. And the professor explained the idea that, it's my business and not the business of the clergy whether I sin. That's a view that he has a right to have. That's a theological view. There's a different theological view, which is actually, as a religious believer, it's not just me and God, it's me and the community that I'm associating with, at least, and God. That's a different theological view. It seems to me the government cannot come in and impose the idea that only individuals have a relationship with God, and not individuals formed together around beliefs, churches, organizations. That would be imposing a non-congregationalist theological view on what free exercise means. Free exercise doesn't just mean me and God. It means we can get together, we have these beliefs, we're going to form a church, we're going to form a group around these beliefs, and we have a associational identity. So I think my time is about it. Those are the main points I wanted to hit.
Professor Culbertson? Sure. Would you care to respond?
Well, yeah.
We still have
You
a
get
few
5
minutes,
minutes.
please.
You get 5 minutes.
Take the time, please.
Now it's going to get civil. Because, well, first let me say, absolutely, the arguments that I was making are deeply connected to a story about liberal individualism. And I find that tragic. Nonetheless, I find liberal individualism to be one of the central myths of our constitutional system. And I disagree with you very strongly that we have a general equity between individuals as rights holders, natural persons as rights holders, and associations or communities. The entire mid-20th century to present equal protection jurisprudence has centered on the fact that this is not a right held by groups. This is a right held by discrete individuals. You're absolutely right that people can and must and could not survive without associations, connections, conjunctions, and whether you want to call them Republican or whether you want to call them anarchistic connections and communal living. That's true. Nonetheless, it's a lot harder as an association, as an organization, as a collection of individuals to meet even the basic constitutional requirements of standing. Right? Similarly, it's true that in the context of individual rights for due process, certainly in the context of criminal proceedings, right? These are all tied to liberal individuals. And so I agree with you. That is the ideology behind the argument I'm making. And I disagree with you, however, insofar as I think that is the ideology that is dominant in our constitutional order. Now, it's not exclusive. It's not total. But it is dominant. I would be very excited to work with you on chipping away at that. However, it does still seem to me that I must have misspoken in some ways, because my suggestion was never that the institutions at issue are violating the free exercise rights of individuals. Rather, my point was to say that if and when the government has chosen as a national policy to make contraception free for every woman who seeks to pursue it, right, through her employer or through her own individual insurer, once they've done that, to allow for a differential obstacle, such as going to your HR person, or having to go have a meeting with your insurance agent, or whatever, once they create a differential obstacle, that then becomes an imposition on free exercise, it seems to me, by the government, not by the employer. And it may be that that sounds better in the key of equal protection than in the key of free exercise, which is to say, if the government has chosen to hold up contraception as a necessary component of social life, of health, and if it holds itself up as able to even enact a healthcare law such as this under the Commerce Clause, then to allow for certain institutions to separate themselves out as institutions, not as individuals, that to me is where I see a problem. Sure, thank you. Sorry, I'll ask you to give me just 1 minute. Oh, and the last point I want to make is that, there's not, it doesn't seem to me, any clear constitutional answer to this issue. we have competing constitutional values. We have the competing constitutional value of, again, equal protection in terms of some of the exemptions. We have a competing value of the interests of individuals to be in a community that not only maintains beliefs, and the individual I was describing was a person who does have those same beliefs as the members of her community. She's chosen to violate them, but she holds them. In any case, that tension of the right to associate with the tension of individual freedom and rights is ultimately unsatisfactorily resolved, no matter how we resolve it. This isn't new, right? The Equal Protection Clause's mandate that public facilities be desegregated ran directly against the individual associational right of white supremacists. I do not bring that up to suggest a comparison between the white supremacists and the Catholic Church or your institutions, but I think it's fair insofar as you started with homosexuals and animal rights and anti-war activists, and I doubt that those folks are of primary concern to many people deeply invested in this litigation. But this tension between free association and equal protection, between individual rights and liberties and the desire and the capacity to be collective and to control your communal life, we've been here and we've done that, and we've resolved it in favor of principles of, I would say primarily, anti-subordination. And this is where the great shame, right? And this is why I can't accept it just as a conversation about conscience. The great shame is that our constitutional jurisprudence has made contraception and made pregnancy and made the status of women a conversation that has no taste for or time for history or reality, insofar as it becomes a question about individual choice, or I'm trying to make it a question of free exercise. It's also a question of equality, right? The fact that women alone become pregnant cannot be separated from the fact that women are deeply economically, physically, otherwise exploited, stigmatized, subordinated in this country. We can't separate that entirely. Now, that doesn't tell us how to answer it. But until we put the differential experience of rights, of resources, and certainly of pregnancy in the context of equality, I think that we're missing a huge component of this argument. Because to reconcile the equality principles at issue in some women's decision to avoid pregnancy with the free exercise values of religious communities, well, here we have two fundamental defining values that are hard to square out. But I think if the desegregation moment is, I think it's very instructive, and we have doctrine on point. We resolve it in favor of anti-subordination and in favor of individual freedom.
Please join me in thanking Mr. Bowman and Professor Culbertson. I know a lot of people have to go. We've got a few minutes before next classes start, but if there are any questions, I can entertain one. Yes, ma'am.
I have no legal knowledge. I'm a physician, but I'm interested in this subject. The only comment I have from a medical point of view, actually, for a woman, being pregnant makes us biologically superior. The way you describe it is your body's kidnapped, you have to ask for our rights. We're actually biologically superior because we're able to be pregnant and reproduce. So it's a great privilege for being a woman and being able to provide that even away from any religious belief based on scientific and biological evidence. And, when you mention the percentage of people that actually go into abortion or the day after pill because of rape or because of medical conditions, it's extremely low. It's unbelievably low. Most of abortions are unfortunately performed for convenience rather than medical issues or because of the consequences. And my knowledge in law is very low, but if you have an abusive partner, I think not getting pregnant is not the answer. I think there are a lot more important things that needs to be taken care of than than just taking a pill. And I appreciate you listening to the other side of the aisle here. And I agree, we all have the right to sin. That's the free will, and every religion believes in that. But you can't force me as a physician to do what you want to do to help you sin, or you can't ask your neighbor to pay for your, sin. That's my take into that. Even if I believe or don't believe in pills or abortion, that you can't force me to contribute to your free will and make it my,
I would just say that relationship that you're describing of a physician, making sure that physicians in executions, that is a direct engagement, right? In a way that I'm claiming that the payment of a premium to an insurance company, which also subsidizes other insurance policies, which may include payment for the production